counsel, Antonio Nicholson. Your Honor, we are here today for sentencing. Defendant was last before your Honor on May 1st of 2025, where she was found guilty of count 5, aggravated menacing. At this time, the counts 1 and 4 were found not guilty. The count 5 also has a forfeiture specification that the court was going to rule on at the time of sentencing. Pre-sentence report and victim impact statement were ordered. State's understanding the pre-sentence report was completed and provided to the court, and I will address why there's no victim impact statement when I speak. And that
All right.
is State's understanding.
Thank you, Mr. Nicholson.
Thank you, Your Honor. Your Honor, my client is 36 years of age, Your Honor. She doesn't have a prior felony record. After looking at her criminal history, I believe the only thing she has on her record is M2, failure to notify the police officer that she had a firearm. But she did have a valid CCW at the time. Your Honor, she is a GED recipient in 2019. Prior to this incident occurring, she was gainfully employed as an operations coordinator at university hospitals for 10 years, Your Honor. She no longer has that job because of the case. Prior to that, she worked at Emeritus Nursing Home in a nurse's aide capacity. Your Honor, she doesn't have any college, but she did get her GED in 2019 at Tri-C. She is currently employed right now with a temp agency, and she's been employed after she lost her last job. And during the pendency of this case, she's being employed the whole time. She has 2 children. One is 17 years old, and she's got a daughter, and she's got a son at 10 years old. That is 10 years old. Your Honor, she lives in Sheffield Lake. Like I said, she has no felony record, minimum misdemeanors. She takes full responsibility for her actions. I think if she could have this back, she probably would have just walked away. Your Honor, she had a really good relationship with her niece. And I know that personally from evidence that I've seen in the case and all of that. And she still loves her niece. And again, she hates that this happened. She takes responsibility for the ag menacing. I mean, she did tell her she was going to shoot her, but that was after she was attacked with a metal pole. But she's not minimizing her actions. We would ask the court to strongly consider community control. She's already lost her job. She had a really good job for 10 years, a job in which she gave her niece. That's neither here nor there, but she's lost a lot. But with all this taking place, she's had a time to sit and reflect that sometimes you need to act differently. But she has carried herself tremendously through these 36 years, albeit from this incident and that little incident for failure to notify, Your Honor. Her traffic record's trash, but, other than that, she's not violent. She came to every court date, Your Honor. She had never violated any conditions of bond. She never tested positive for any illegal substances or alcohol or marijuana. And, Your Honor, again, she was gainfully employed throughout this whole pendency of the case. And, Your Honor, she didn't catch another case while this was going on. This case was going on for a long time. But she conducted herself accordingly. And, Your Honor, she's here. She knows that there's a chance that she can go to jail, but she still showed up as she has every other court date. Your Honor, I'd ask the court to strongly consider community control. I think she should get some type of consideration for going 36 years without a major offense on her record. I believe she wants to address this honorable court. Everything that I've said, Your Honor, I'd ask that you take it in consideration upon imposition of your sentence. Thank you.
Thank you. Ms. Fryer, what do you want to tell me?
As Antonio stated, and I'm so sorry, because as he stated, I've never went through any of this in my whole entire life. I had a great job, which I have lost, which of course it's university hospitals. I've intended to retire from there, but now all that's gone. And I would say, if I could go back, I would definitely do something different to make a threat for anybody, even my family member, to believe that I would harm them, which I would never harm anyone, not even my family. So just the fact that she believed that I would even cause physical, and I did not mean to even cause mental harm to her, because I know that may have affected her mentally as well. But that was never my intention. And of course, in the heat of the moment, as everything is going on, the threat was not going to be carried out, of course, but at the same time, it should not have been said. I never intended or would shoot anybody. And I honestly really wish that I could go back, but I'm here now, and I take full responsibility for all of my actions. And at this point in time, regardless of who it is, family, friends, people that I don't know, I know from now on to walk away and not say anything for situations like this. And that's all. Thank you.
Okay, thank you. Ms. Cutts?
Thank you, Your Honor. Obviously, this court has heard more than you often would in a case, since this did go to trial. Victim advocate has been in contact with Shemaya. Initially, she had indicated that she was going to come to court and to do a victim impact statement. Obviously, this involves family, and it has been very hard on Shemaya with all of the other individuals involved who were concerned about her going forward. She had indicated that she did nothing but tell the truth about what occurred, and that instead of coming and writing a statement, she would leave it up to the court and any higher being to determine what should be the outcome. But she did indicate, as she has consistently with me, that she had told the truth about what had happened. She had never been treated like that before, and was shocked by what had occurred. In the body camera that was provided in evidence, defendant's daughter did state that she did have a firearm in her hand and corroborated a lot of what occurred. So obviously we have here physical and psychological harm. The court was able to see the photographs of the marks and cuts on Shemaya's face, neck, and the bruising on her leg. Obviously this was a family member, it's her aunt. She had a firearm, it was found to be loaded. Shemaya's daughter was present, she was about 18 months old at that time, during the altercation, during the threat, and the firearm being pulled. So we would ask the court to find the forfeiture. So the relationship did facilitate the offense. At that time they were living together. Defendant does have a conviction for attempted improperly handling firearms in a motor vehicle. That is a misdemeanor of the second degree. I believe that conviction was in 2022. The firearm was forfeited at that time, and fines and costs, and she does have a lengthy traffic history. She does not have an extensive history. This has been very stressful on Shemaya and the family, because obviously there is a loving relationship in some aspects. Shemaya does not feel as close to her aunt as perhaps it was presented, but we do think community control is appropriate, obviously in this case, but we do think jail time would be appropriate as well. She has 2 days credit. We'd also request a mental health evaluation and follow any and all recommendations, that she engage in anger management, parenting classes, that she not use any drugs or alcohol and have periodic screens that come back negative, that she engage in full-time work, that the firearm, magazine, ammunition, and holster be forfeited, that she have no contact with Shemaya Frierson, pay any costs and fees, and that she be aware that if she were to violate, she could get up to 180 days in jail on this matter. So just wanted the court to understand we have been in contact with Shemaya, but just based on the family nature and all that was going on, she didn't feel that she should come back into the court. She wasn't comfortable with that, so she wanted to pass that on so she was not disregarding anything in that sense. And that would be the state's recommendation at this time.
All right, thank you. I've reviewed the pre-sentence report. First of all, I'll find that the firearm, magazine, and ammunition and holster were used as instrumentalities to facilitate or to commit the offense of aggravated menacing, so I will order those items forfeited to the state. I reviewed the pre-sentence report and considered all the applicable statutes. In consideration of everything, I'm going to put you on a 1 year of non-reporting probation. Sentence will be 180 days in jail with 178 suspended and credit for 2, and the costs are assessed. Is there anything further, Ms. Cutts?
Nothing further, Your Honor.
All right. Ms. Fryer, you have the right to appeal this conviction to the 11th District Court of Appeals. And you have a right to have a lawyer represent you in that appeal. If you can't afford one will be appointed at no cost to you. You have a right to have a transcript of all the hearings in this case. And if you cannot afford a copy of those transcripts, they would be given to you again at no cost. You also have the right to have the timely notice of appeal filed in this case. Is there anything else, Mr. Nicholson?
No, Your Honor.
All right, we're adjourned.